But the problem
Mr.
is,
DeCastro is supposed to know that he has to back up further. DeCastro? Do we have, everyone we need on DeCastro?
Yes, sir.
Is this Mr. DeCastro?
It is in custody.
Okay, he is present, he's in custody, and the attorneys can state their appearances.
you understand,
Your Honor, Christopher Oram on behalf of Mr. DeCastro. Did you want him to sit down?
no, you can stand up.
But you can sit down if you want, you don't have to stand up throughout the whole hearing.
Sit.
It's up to you. Might be a minute.
Alexander Chen on behalf of the state of Nevada.
Mr. Oram, I'm assuming.
May I proceed, Your Honor?
Absolutely.
It seems that everybody agrees you have a right to film police officers. I'm not sure. I filed a lot of federal case laws suggesting you can film police officers, but the state doesn't seem to dispute that. In this case, you have a person who, for a living, this man for a living, that's his living, he films police officers. He has more than 500,000 subscribers. He is very, very famous as a First Amendment auditor. He is known as he testified around the United States and does this constantly. As I look at this case, there are multiple problems with it. It goes to trial, so let's start with what really happens. There's a letter written to the judge, and I cite to it, and you have a copy in the appendix. And the letter says this man's going to film the proceedings. So before the trial starts, the judge says, empty your pockets, suit pockets, all sorts of pockets, empty them. He says why, he complains it's a Fourth Amendment violation, you don't have a right to take my phone. And the judge also demands that defense counsel turn your phone off. And she said, I don't want to be part of your YouTube channel. And he said, we already are. This is the starting point to this trial. And the state says, well, the court has a right to, keep the court secure. Absolutely you do. Absolutely. Have a right to determine who's filming. Absolutely. But what was interesting in the state's argument is they forgot to mention that the court never looked at the prosecutor and says, hey, turn your phone off. Make sure your phone's off. It was all directed at him and his attorney. You can't take cell phones. You can't do that. It's structural error to do that. And it also kind of shows that the court had an animus towards Mr. DeCastro, then judge. He makes a statement to the marshal. It's unacceptable. It's unacceptable. It's clearly unacceptable. The judge was agitated by it, understandably so. As I look at that, I'm like, I come in these courts all the time. You don't get to call a marshal what he did. So, I understand. That's a different matter. He's not on trial for calling the marshal a name, which he should have called. Maybe you could hold contempt proceedings for that. There are remedies that a court like yourself can do if somebody's being disruptive. Just because somebody's disruptive in a murder, calls your court staff a name, it's inappropriate. I would realize with a client, oh boy, this is not looking good. But that doesn't mean you're going to find or suggest that the person committed murder simply because he's acting or she's acting in a fashion in a courtroom that shouldn't have happened. But it was clear then that the trial was going the wrong way. So when we look at the facts of the case, that the police officer testifies that this auditor approaches, says that he's a member of the press, identifies him immediately as a member of the press. I have video here. I also have exhibits. And that he wouldn't back up. Now at trial, that was commented on by the officer a couple of times. He wouldn't back up. He wouldn't back up. The prosecutor argued it. Then they started on the 21-foot rule. It's an imaginary rule. We all know there's no such thing as a 21-foot rule. It doesn't exist. But nobody was stopping that. Not defense counsel was saying, where is this coming from? What rule are you coming to with this? And the prosecutors arguing, well, he's violating the 21-foot rule. There's no such thing as a 21-foot rule. And the state, to their credit, has abandoned and completely retreated from the 21-foot rule on this appeal. They don't argue.
Did he testify it was something he learned in the academy?
Yes. Yes, but I understand what it is, Judge, because I've used it myself in murder cases, and that is what they're taught and what I've argued that my clients are enduring is that if a man, an assailant, comes at an officer or a citizen, within 21 feet you won't be able to draw your weapon. That's what they're taught. So it's something that we use in a self-defense case. Oh, look, the guy was, coming, and so my guy had no choice but to shoot. I understand that's what police officers are taught. But that's got no bearing on this. There is no 21-foot rule. And in fact, we just go to Chille. Chille is a First Circuit case. Both the state and myself rely upon it. And in Chille, I thought the language was so important to this case, because in Chille, they begin speaking about that officers, in that case, person's filming on the Boston Common, filming from 10 feet away, 10 feet away. That's very relevant because the police officer in that case said Mr. DeCastro was 10 feet away. And so the First Circuit said that is 10 feet away, and then the First Circuit starts saying, police officers need to deal with provocative and challenging speech. They further identify that when a police officer comes in contact with somebody who's being rude or obnoxious, that they feel like they shouldn't be filmed, that they shouldn't have to endure that. And the First Circuit then goes on to talk about that officers sometimes retaliate because they don't like it. They don't like it. And they said that's what happened in Chille. The officers didn't like it. You don't film us. You have no right to film us. Okay? And so when I look at the situation, I'm like, officers, we have a right to film officers. In fact, we have an actual statute on it. NRS 171.1233. This is cited in page 2 of my reply brief in footnote 1. Subsection 2, subsection A states, a peace officer shall not act to interfere with a person's recording of law enforcement activity, including, without limitation, by A, intentionally preventing or attempting to prevent the person from recording the law enforcement activity. You got a right to do it. We know it by statute, we know it by federal law. So, what does Mr. DeCastro do? When the officer tells him, back up, I can prove he does. I've attached the exhibits. If the state wants me to, I'll put it up and I'll show it, but we can see from Exhibit A that where Mr. DeCastro is standing, he's standing in a particular parking space. We can see in Exhibit B, he has now moved back into the back parking space. When I say back parking space, I know that may be not a good record, but he's moving over.
Right, it looks like it's in a parking lot.
Yes, it's a parking lot. He's moving from one parking space away. You can see it's away from the officer. So the state, to continuously argue he would not back up. Why are they doing that? Because they want to say he won't follow the commands. And the accurate answer was, and I think the court would say, if you were asked to look at this case and say, what did Mr. DeCastro do when he was told to back up? He backed up a short distance. That would be fair. Maybe the court would not like that language, say maybe it's a few feet. But he did back up. What is not fair is he would not back up. He would not comply. He did not back up. And then the officer was asked, did you tell him how far? No, because he was disruptive. So I couldn't tell him how far. The 21-foot rule. There is no 21-foot rule. Chille said 10 feet was fine. And in Chille, what's more interesting about it is the officers, what Chille is deciding is not like this court deciding whether there's a criminal activity. Chille is suing the officers. And the officers are over in federal court saying, oh no, give us qualified immunity. And the federal court saying, no, not for this. You're not getting, for arresting somebody who's filming, you're going to get sued. You're not getting qualified immunity. You're going to have to fight this and go to a jury. I think that's very relevant because that's what's going to happen with this officer. Undoubtedly, he's going to sue, and I think he's already started that process. I'm not a civil lawyer, so I don't do that. But I know that that is what's taking place. So what is hindering this man from obstructing him from writing his ticket? He can just simply write the ticket. He can look at Mr. DeCastro and think to himself, here's one of these auditors, walk over and write a ticket. He was asked the question, which I thought was really good at trial. He was asked, how did he obstruct you? How were you obstructed? And he said, well, I didn't know what his intentions were. I didn't know. Maybe he was armed. Well, that doesn't obstruct you. How does that obstruct you? He never gets in the way. So let's fast forward to Wilson. Okay? 3 weeks before this trial, the Court of Appeals considers one of my arguments here that the statute is unconstitutionally vague and ambiguous. The Wilson court determines that the only way that you impede is that you have fighting words or you physically do it. And the exact language of it is, we interpret 197.190 as applying only to physical conduct and fighting words. The court further explained that blocking the path of an officer may amount to obstruction. Well, we know that didn't happen. We can look at the video. There's no blocking. There's no blocking that goes on. And they also say that it could be non-aggressive, which made me curious. So I went and read the case. I thought, what could non-aggressive be? And it makes perfect sense. I would have never seen how non-aggressive could be obstruction. But what they then cite is they were pulling over an individual, police were, and then the guy, who I guess is armed, then starts to run from police. Well, now they've got to go chase him. So clearly you're hindering the police. So that made perfect sense, and that's the case they cited. What is interesting about Wilson is they also go on to say, as construed by this court, NRS 197.190 prohibits only physical conduct and fighting words that hinder, delay, or obstruct a public officer in the discharge of official duties or powers. As such, law enforcement has no discretion to arrest persons for protective speech or for physical conduct that is merely annoying and offensive. Judge, I have no doubt, I know you've watched this video, and I could see how anybody could look at this and hear the speech, get in your car, little doggy, and write your ticket, and find that to be annoying. I see that. But that's protected, and we've been told that's protected now by our courts in Nevada, by numerous federal courts. They went on to say the district court did not, so in Wilson was convicted, appealed, just like I'm doing here. And they point out in Wilson that on appeal, this court explained the district court did not have the benefit of our interpretation of 197.190 as being limited to physical conduct or fighting words, and it therefore did not consider whether there was sufficient evidence that Wilson engaged in physical conduct or other fighting words so as to support her conviction, and the case was remanded. Why I think that's important is because one of sort of the big picture that I want the court to see that I'm arguing, I think Judge Zimmerman was put in an absolutely terrible situation. Here's one. Look at all this litigation we're doing here. This isn't new. I didn't come up with, oh look, there's a new case that came out about a First Amendment issue. A lot of the cases I'm citing are, 20 years old, 15 years old. This is known law. If we have this issue before you on a case, isn't it incumbent upon me to file this pretrial?
I wonder why that didn't occur in this case.
And the state says something interesting, which I understand the state's advocating. The state says that trial counsel filed a memorandum. Well, I'm like, it was comical. I understand what the state's doing. They're saying they need to try to protect their conviction. But the trial counsel, what he did is he filed some memo that right when the judge is making her decision, finding him guilty, she's like, what memo? He said, well, I filed them. She didn't read, and then the state correctly, the state said, strike it. It's late. So what trial counsel does is, at the last minute, can you imagine I'm coming in here talking about the facts and all of a sudden I'm like, oh, Judge, there's a First Amendment issue. Like, well, don't you think you should have briefed that and let me know? And I hear the state's argument, and the state says courts are presumed to know law. And I know you know law, but I also know, Judge, that we get into issues. You've been on the bench a long time, so I know you know the law. But when, let's say we're going to talk about a Miranda or Messiah issue, I think that it's incumbent upon us to give the material to the court, let the state oppose it, let us reply so the court can look at everything, have the court's clerk go maybe find research that interests you on this so that you can make an informed decision, as opposed to at the very last minute in a factual trial, like, oh, by the way, there was a Messiah issue. I don't understand why he did that. This was the issue. This should have happened beforehand. This should have been litigated beforehand. The court, like yourself, just like we're doing here, we should give you the opportunity to go look at it, and maybe my rendition of it is not the way you want to go, it's the state's rendition. But the fact of the matter is, at least you had it, and Judge Zimmerman didn't. And that's ineffective, because he should have showed the court these issues. And if he had, just like here, the Wilson case would have come up. I know it was brand new. It was only 3 weeks before the trial. But then the court could say to the state, hey, you've got to have physical conduct or fighting words. We can't just do this on driver safety. Because at one point, the judge ruled, because the prosecutor kept arguing, and the police officer testified, well, the driver had a right to privacy. Like, the driver doesn't have.
The driver's out in public. I don't
Right.
know if
Right.
the driver had a right to privacy. When you're out in public,
You don't have a right to it. And here's another thing, Judge. The state then comes back in their response. Mr. Chen always does an excellent job, and he did here as well. And he cites a bunch of cases, every single case. It made me realize when I read it that they have real legal problems. They've got problems with the law. Because what I did is I read every single one of their cases, and what I found is, oh, this is not at all what these things stand for. In other words, in fairness, they were saying their time, place, manner restrictions. Yes, true, the cases did stand for that. But let's start with Philadelphia, Fields versus City of Philadelphia. Now, when I first saw the video, what came to mind, just jumped to my mind, was I looked at it and thought, hey, wait a second. Didn't those people in George Floyd, weren't they filming it with cell phone? Now, I hadn't really followed it that much, but I kind of thought about it and it ran through my mind. So I then started pulling up the exhibits that I put and I looked at it and I said, well, boy, those people are closer. They're closer than Mr. DeCastro. Another thing that came to mind is, although I didn't really follow that trial very much, I did remember the firefighter. She's an off-duty firefighter, and she came to court with her uniform on. It was devastating for those officers because she said, I tried to tell them, and then they started saying, if you were a real firefighter, you'd know not to get involved. And she said she started using profanity at the officers. And she, at one point, is within a foot of the officers. There's an Asian officer in the back of the vehicle, and she comes very close to him. When I look at that, I'm like, well, how is she not in the same situation as him? She's admitting she's using foul language. And I remember her trial testimony where she was crying, and I think it was extraordinarily impactful. I want to talk about something for a second, Judge. Police have to deal with difficult people. I know that because I witnessed it in your courtroom. Right there, right back there, right by the door. And I seem to remember, I was in a capital trial, came up from a break, about 1 in the afternoon, and what I see is Officer Hawks having to deal with, I don't know if she's a homeless lady or what, sort of small Caucasian lady, but out of control, and I'm watching, almost nobody's in here, and she's saying horrendous things to Officer Hawks. He there comes back up, because I know there was a female officer, and they're trying to talk to her. Your marshal showed incredible restraint. I know that because I watched her try to kick him in the groin. She tried to kick him, and I watched it happen. And I don't think she was arrested. At some point, they did everything they could to just get her out of here. She was so obnoxious and abusive to your marshal, yet the restraint shown was remarkable. I remember that because I addressed it with Officer Hawks. I said, how did you do that? To me, it was amazing that a human being could practice that type of restraint, and that's what he did. And that's what this officer should have done. He was angry. When the state says to you, and when the officer said, I was concerned for officer safety. No, he wasn't. At the point when he says to him that annoying language that we call, and the federal courts have said it, provocative and challenging, get in your car, little doggy, and write a ticket. First of all, he's telling him to write the ticket. He's not obstructing him. He's just, it's like a directive. Counsel, be quiet and sit down. Okay, that's a directive. But you're not obstructing me from being quiet and sitting down. He's telling him to do it. And so I don't understand how the state can argue when I can see it for myself that the officer was concerned for officer safety. When he says that, when Mr. DeCastro says it, you can see the officer just gets irritated beyond, my God, you don't say that to me. He just comes at him. He doesn't pull a taser or anything like that. He's like, you're detained. And then he grabs him pretty hard. And he's trying to say, well, I'm a member of the press. I'm a member of the press. You can't do this to me. He tells him, call your supervisor. Don't do this to me. And he's like, he brings out 2 cell phones, so you know he's not armed and you know what he is. And even the officer said he knew about First Amendment auditors, but didn't say that they shoot people, because he was asked that. And he goes, I don't know if I said that. You know he was agitated. This wasn't about fear. This was about, truth be told, you can see it's obvious. The police officer was agitated. And the federal courts talk about that. They talk about a lot of these officers don't want to be filmed. And I want to go back to City versus Philadelphia, or Fields versus City of Philadelphia, because in the state's answering brief, they question, why would you be bringing up Floyd? Are you bringing that up? And I realized the state saw, why are you bringing it up? I saw it was directly relevant to filming police. So since they cited Fields versus City of Philadelphia, I went and read it. And it starts off, so what that is that's an individual who's got concerns about unions and they're filming in Philadelphia. And the court starts off with very, very, very interesting language. This is the Third Circuit. The Third Circuit begins their analysis This is the start of the decision. In 1991, George Holliday recorded video of Los Angeles Police Department officers beating Rodney King. They continue to go on about that. I cite that on page 4 of my reply. This case involves retaliation. Individuals making recordings have also faced retaliation by officers, such as arrests on false criminal charges and even violence. And that's because they're recognizing this. The federal courts around the United States are recognizing that police sometimes don't show the restraint that Officer Hawks does. You know, if you're being filmed and you got some irritating person, sometimes when we walk out of these courts, we got press that are like, what just happened? Did your client just get convicted? It's like, yes. Did your client just, they want to sentence him to death? Yes. And you have to be calm. I can't just grab people and do it. You got to suffer it. Suffer it. He didn't stop anything. He didn't grab the officer. He backed off from the officer. Yes, maybe annoying. Yes, maybe provocative. But it is not obstruction. It's not resisting. These are trumped up charges. And that's what the cases show. They can't show you a case. Not a single case could they rely on to show this is obstruction or resistance. Not once. And in fact, like I said, I think trial counsel should have presented it to the judge beforehand. Then the judge could make the correct decision without even a trial. I think if the court had seen it beforehand and not being so agitated by calling the marshal a name, that the court could have ruled that this is clearly protected First Amendment speech. Judge also, so I believe that I've argued that this is a First Amendment violation to convict him of it. It's also under the Wilson decision in the case, federal case law we've cited, it is clearly arbitrary and capricious. It's being applied incorrectly, and the court did not have the benefit of the Wilson decision because Wilson remanded it to tell the district court, you need to look at this. That did not happen here, and so that's a problem. I argued judicial bias. The state claimed that there was no objection. Again, trial counsel didn't object when phones started being taken, didn't make any kind of formal objection. But in Echeverria and in Gurry was my case, it's murder of an FBI agent, there was no objection. It was well before my time, but I do it on post-conviction. I handled it on post-conviction. And it was that the trial judge had been, the FBI agent who'd been murdered, had actually investigated the trial judge. And so they found that that was an implicit bias, and so therefore there was reversal. The judge should have recused herself. She should have realized maybe I should hold this man in contempt, do contempt proceeding, and send this to somebody else. She didn't do that. But I also think it was incumbent upon defense counsel to do a better job and inform her of that. And that leads into my last argument of ineffective assistance of counsel. And I know that on appeal it's rarely considered. However, I cited case law that it's clear as day, and I think the court can already see why wasn't this brief? Why is this whole hearing not happening prior to the trial date, so that Mr. Chen or whoever, it was Miss Agnes Lexis, why didn't she argue this against trial counsel and let the court make a decision? Judge, under the circumstances, reversal's mandated. It just, in every different area, I think under the Wilson decision, I think under the Click decision, I think on every single decision. And so I just want to make sure, Judge, that I cover all my points before I turn it over, and that is, they say Mr. DeCastro was angry and hostile. No, this is what he does for a living. That's how he approaches them to see, can they handle it? I think in other videos, if the officer handles it well, like Officer Hawks, then he kind of calms down a bit. He did back up.
I'll object to that as facts that are not in evidence, speculation.
I'll withdraw that argument. And what other time, place, manner restriction? When to do this as an auditor, to do this?
This is a Target parking lot, right?
Yeah, in daylight, broad daylight. When if it was a female officer, not that if it's a female officer on a lonely highway going up to Ely, and all of a sudden somebody's approaching at 3 in the morning, I think that's a different story. That shows officers like, God, what's happening here? And it's fearful. He does it in the most common way. He comes up, I'm a member of the press, annoying, provocative, all of those things, but it's protected. It is one of the most, it is something that is sacred to what our system of justice is. And one of the decisions I cited said, this is the difference between us and a free society, where we can go up and be obnoxious to police. Hey, I see what you're doing. I remember from the time I was in law school, I couldn't cite the case, but I wonder if you remember, Mr. Chen remembers it, where somebody comes up to an officer and calls him a pig, which I think is really, I remember as a law student feeling, you shouldn't do that, that's bad, right? But the reality is, I then learned from the Supreme Court, it may be bad, it may be obnoxious. If it's your child, you'd be like, what did you say? But it's protected, Judge, and he didn't do anything to violate or have those protections taken from him. I'd ask that you practice.
Mr. Chen?
Thank you, Your Honor. First, I'd like to thank Mr. Oram. Considering that our response was called comical, I appreciate the nice words from him today. Regarding, first and foremost, with the ineffective assistance of counsel claim, even if counsel could have done it, we're still focusing on the prejudice problem. Ultimately, we're here, and this is the appellate court for this matter, so this court's going to make a matter of law decision. So I think ultimately, everything regarding that issue gets resolved on a prejudice problem, whether or not Judge Zimmerman was apprised of the information that he wishes to put forth today. Now, with regard specifically to the First Amendment claim, Mr. Oram mentions that we cite to a number of cases, and the cases factually don't support our position, and I think we recognize that in our brief. There are cases where police officers have stopped individuals from filming encounters that they absolutely had a lawful right to do. This is why the court consistently talks about time, place, and manners restrictions. We don't doubt that that's the case, but to suggest that we didn't read those cases, I think is an unfair characterization, because what we're trying to focus on is whether the time, place, and manner restrictions were present in this case. Now, what I would argue, and what I think we argued in our brief, is cases like Glick are relevant to the extent that in that case, the individual clearly was not impeding, obstructing, or being a problem to police officers. The only thing that individual in Glick was doing was filming officers, and the officers were upset by it. That's a very different situation when we're talking about time, place, and manner in this case. Yes, it's in a public parking lot, but you have to realize that as the facts came out, that the officer was letting the individual film until he approached the driver. Now, I agree, privacy is not a thing necessarily in public, which is why we didn't argue it. However, there are other concerns for time, place, and manner regarding safety of everybody involved, including the fact that when the officer is writing a ticket, when the officer is communicating with this lady who's been pulled over, when that lady is sitting in her car and not free to move because she's subject of a traffic stop, that the scene needs to be secure. Now, I appreciate that the individual, Mr. DeCastro, could have plenty of followers, and he might have followers. I didn't know of him before this date, and it doesn't appear that the officer did either. So ultimately, the officer is treating this individual as someone who's filming, but doesn't know what the ultimate motivations are. It could be to film, it could be to do something else, it could be to interfere with the driver, and I think that's what the evidence shows in this particular case. Not only did he approach the driver, the key part where the obstruction begins to occur is when the officer asks him to back away from the driver. He says, well, I'm a filmer. Great, you can film, but I need you to back up. And again, we're quibbling over how much the backup was, but I think
Clearly backed up.
he backed up a couple of feet. There's no question about that. But I think what the officer testified to was he wanted it at a further distance based upon, in large part, how Mr. DeCastro was operating. Now, if Mr. DeCastro had backed up a number of feet and continued recording and wasn't saying and doing the things that he was doing, I think we'd have a very different situation. But the problem is,
Mr. DeCastro is supposed to know that he has to back up further.
the officer instructed him in the video that to continue backing up, and rather than backing up further, he stood his ground and said, no, I'm relying upon a fictional 10 feet rule, which I don't think is a matter of law. I don't think the First Amendment says 10 feet is automatically permissible, because you can do a lot of things
There are courts that have held 10 feet is sufficient.
depending on what the situation is, all right?
I agree.
If I pull out a gun, is 10 feet still sufficient? We're an open carry state, for instance, so there are individuals who can carry guns. So if we were to say automatically that I'm 10 feet away, and that as a matter of law, that's sufficient, I think it's very different if the individual is doing certain things. If the individual has a grenade in their hand, that's why it's time, place, and manner specific. We're not advocating, I didn't advocate for a 21-foot rule, even though that's what the officer said he was trained to do, in that he wanted the individual to move back a certain amount.
But he never vocalized that.
He didn't.
He never verbalized, said, hey, you know, I want you to move 20, 21 feet back, go back to this line, don't come across this line. There was none of that, because it happened so fast. I mean, the officer testified it was within like 10 to 15 seconds.
Yeah, it's all on the video as well, Your Honor, so I agree that he doesn't give a specific number. And even if he had given a specific number, it's not that that specific number is somehow constitutionally permissible or not. But the point is the manner in which this individual, who's unknown to the officer, is interacting with that officer in that very manner is what the issue is for us. And based upon that, the officer can't continue to feel that he can do his job, the traffic stop, speaking with the individual, of doing any records checks that need to be done, of writing the actual ticket, while this individual is yelling, refusing to move back at a further distance, and again, with unknown motivations. In hindsight, we can look at him and perhaps say, well, he was only here to put this on his YouTube channel, but ultimately, at the time that it's happening, this officer who interacts with him, who even tells him, you're allowed to film, but I need you to continue backing up, I think that's what the reasonableness is, that's what the time, place, and manner restriction is, not some magical number. As we point out in our brief, I think what Mr. DeCastro believes and what counsel believes is that because Blake said 10 feet, that there's this line of 10 feet, and no matter what, I can do whatever I want within 10 feet. And I think even Wilson, although I understand it's remanded for further hearings, goes against that proposition that, oh, there's some type of magical number or anything like that. This individual in Wilson is yelling as there's a suicidal individual who is obviously a delicate situation. The police don't want this individual to hurt himself, and Wilson continues to yell and interfere with what's going on. Specifically in Wilson too, that even though they say physical conduct again is made up of multiple different things, including what we do with our bodies, but as well as what we're saying and how we're acting throughout the course of the interaction. And Wilson acknowledges that. In fact, they cite a treatise, what constitutes obstructing or resisting an officer. And if you look at that particular treatise, I mean, it goes on for multiple pages of various conduct that would entail obstructing. So here, it's not simply about the words. It's not simply about the fact that Mr. DeCastro was annoying. It's not simply about the fact that Mr. DeCastro was saying things like calling the officer doggy and whatnot. It's not about that. It's the totality of the circumstance which prohibited the officer from being able to safely and adequately conduct the traffic stop. And that's.
Well, he immediately released her
He did.
also. I mean, he gets out of the car. I mean, it appears to me he was gonna release her regardless, because it was so fast. He said, you're free to go, and then he went to take care of the other issue.
Yeah, well, I mean, what we have in this particular one is he went and did the records check, and then he mentioned too, she was surprised or even confused by the fact that she had an issue with her registration. Exactly. Now, again, I don't want it, it's speculating to assume what happened there, but certainly those are the facts that came out at trial. And so ultimately, whether he was going to take it or not, he may have taken her. Obviously, he pulled her over because the system, as he testified, said that there was an issue with her license. But because of the fact that this all went on, perhaps the obstructing was that he didn't feel comfortable to write. It wasn't worth writing this ticket. She already was informed of it so that he could deal with this other situation of this individual who's clearly obstructing with his ability to get to the very end of his investigation, whether he was going to release her or whether he was going to write the ticket. But the problem is the impediment is the individual who's continuing to yell and stand a number of
You
feet
could
away.
never do that then, if all the officer had to do was say, because I had to go deal with this, I couldn't write the citation, right?
I think it's time, place, and manner specific though. In this particular case, when you watch the video, I think he is that much of a problem that this officer ended up, talking to him more.
So, but what's the obstruction? It's not the words, and it's not the filming. I mean, the officer, to his credit, he said right away, you can film, you just need to back up, And I understand he didn't want him talking to the driver, but it didn't appear to me as though after he was instructed, don't talk to my driver, he didn't talk to her anymore. Is that accurate?
That is accurate, yes.
Right?
And
It's-
everyone testified to that.
Right, and then he backed up. I mean, I understand the officer didn't think it was enough, and so, I mean, is it just that he didn't back up far enough for the officer? That was the obstruction?
He didn't back up far enough in addition to the manner in which he was acting. So had there been a conversation saying, officer, and again, everything is so fact specific, right? But the
Right.
fact that DeCastro is immediately yelling, arguing with the officer about the amount of backing up that needs to be done, that's what the issue is. It isn't about the space in itself or the distance in itself. It's a combination of factors of everything involved. Now, Mr. Oram says that depending on who the officer was and where it was at night, I believe where it was could play into it, but I think it's an unfair statement to assume that some officer, simply by virtue of being a female, would somehow be in an incredibly worse position, and that Mr. DeCastro, for instance, could treat her differently or would need to treat her differently than the officer that we have involved here. I think
Well, if it was in Ely on the side of the road at 3 a.m. on that road between
for any individual,
Reno and Vegas,
for any individual, I would agree. For any individual.
I agree.
I'm just saying that it seems incredibly sexist to say that somehow a female officer would be unable to defend herself on that Ely road, but somehow a male officer would be automatically good to deal with the DeCastros of the world who want to interfere with the investigation. That's what I'm simply saying, is that I at least wholeheartedly disagree with the characterization there in terms of the time, place, and manner. But I agree, an isolated road could be a factor. But they're all just factors. This case has its own facts. There will be other cases that come through the line, but I'm just arguing that pursuant to these particular facts, he was convicted of obstructing. And Mr. Oram doesn't address at all that second issue, which has to do with the resisting portion of things. Now, I think the case law is
that
clear.
Lisenby case, I mean, so even if I agree that this was an obstruction, it was unlawful to detain him, that Lisenby case seems to indicate he still can't resist.
And that would be our argument. He hasn't addressed it, I'm sure he will on his reply, but that's the last of my argument. Thank you.
And I'll address that. First of all, I didn't mean in any way, Judge, if you could take the biggest male officer, I meant just giving the scenario, it could be 1 in the morning, 3 in the morning, female, male. I didn't mean it that way. I just meant the visual of how it's different there. What I just heard was sort of interesting. Mr. Chen just said, I didn't argue the 21-foot rule because it didn't, it's not applicable. They sure did at trial, didn't they? That's what they argued. Even the prosecutor argued it. So Mr. Chen is only retreating from it because it's not a rule and it makes no sense. It's something used, as we talked about, in self-defense type issues.
Right, but if the officer would have said that, I'm not sure that would have been unreasonable.
I
really want you to be about 21
Yes.
feet back,
Yes.
give me some space, and,
Right,
don't go past this white line. I mean, there were markers in the parking lot.
right. And if he had grabbed his citation started and Mr. DeCastro got in the way, you're not going to do that. It's obstruction. This is an obstruction. And the 10 feet, I agree. Is it 10 if you're only 9.5 feet? Is it correct? No, I don't think that's the point. The point they're trying to make is that our statute tells us we can film police officers. It doesn't say 10 feet, 21 feet. It just says filming them. When he was told to back up, he did. And the state is now saying, yes, we all agree with that. We're quibbling over words. I'm only quibbling over words because they kept saying at trial he wouldn't back up, which is not quibbling with words, it's inaccurate.
That's true. I mean, the officer did testify on direct examination repeatedly that he didn't back up.
Yes,
But on cross indicated, well, he did back up, he just didn't back up.
substantial.
Yeah, he may have backed up inches, he didn't substantially back up.
Now, with regard to what are the intentions, I keep hearing, what are these intentions? He didn't know what the intentions are. And then that's why I put up, because I think there was testimony that I don't know who this guy is connected to. You don't know who this person is. Well, the officers in Floyd didn't know who these people were. The people filming, they didn't know it was an off-duty firefighter. They probably had done something different if they knew who they were dealing with. But they didn't know, and so the same arguments could be made. Oh, they're within 10 feet, officer safety. Maybe those are all gang members and they're the same gang as George Floyd. It's his brother, I don't want to be sexist, it's his sister who's gonna pull out a gun, or some other person, male, female, gonna pull out a gun and shoot it. So we are doing this for officer safety. No, it isn't. And the courts, you can look at George Floyd and realize the courts in a big case in the United States said, these people have a right to do that. And the question I really ask, I think is important. There was no abuse. The officer wasn't doing anything abusive to the driver. It's clear as day, okay? But if he was, and he caught it on film, and now it's hitting CNN and Fox and all of this stuff, then they say, oh yeah, we caught him, and 10 years from now, the Third Circuit's going to be quoting what he did. But he didn't catch them. So is that the standard? Can we film police officers? But if they're not doing anything wrong, and I'm using obnoxious language, then I can be arrested? Is that what the standard? It isn't, Judge. The application.
You're allowed to be annoying.
I'm sorry?
You're allowed to be annoying.
You're allowed to be annoying. You're allowed to say,
You're allowed to be obnoxious.
Yeah. And I realize, we as lawyers appear in front of judges all the time. We appear in front of juries. We're trying not to, you don't want to be obnoxious. It won't help your case. It won't help that. But I recognize this is some cornerstone. It's a foundation of our nation. The resisting. Did you notice the officer said, oh, when this resisting is happening, my body cam all of a sudden doesn't go out. He testified he never resisted. And you can see it on him. He tells him, don't do it. The officer really grabs him hard. And then he's like, okay, I'm walking. You even see him with his camera. I'm walking back to your car. There's no resisting. He's trying to tell him, you're being unconstitutional. He does say it. You can't do this to me. Call your supervisor. But they get him in handcuffs, and there he sits. By the way, the state didn't ask for him to sit there. Agnes Lexis asked for a suspended sentence, and Judge Zimmerman decided to give him the maximum. He's been in there 4.5 months for this. And I kind of wonder.
To that characterization, it's not a maximum. It's 3 months on each count and consecutively.
Right, yeah.
Oh, you're right. Okay, you're right. I stand corrected. For whatever reason, I guess misdemeanor 6 months. Yes. So she gives him, but the state didn't ask for that. They asked for concurrent 90 days suspended. It goes to show what really happened. There were so many different errors, and I can tell the court has a good handle of this. Judge, there is no resisting. It was an unconstitutional arrest. The man should receive the benefit. I mean, we have a beyond reasonable doubt standard. We can look at Wilson. I now hear the state really struggling. They almost sound like me in a bad murder case where they're saying, well, what is physical conduct or contact? Because that's what Wilson said. And they're struggling with it because they don't even, because there is no physical contact. Backing up and filming and then pulling out a second camera, it's not physical conduct. There's nothing physical. He doesn't do anything physical. The officer just lost control. And he was irritated. Maybe we understand. It's not.
Yeah, you can understand. Yeah. I can understand.
Okay,
and it kind of comes out of nowhere.
It's out of nowhere. It's, who wants to be called names? But that's what the courts are all saying. You've got to endure this. Our citizens have a right to do this. And it also keeps our police, these auditors, do help in some way because sometimes they prove police are doing, if there was an auditor on what he did, and that woman was like, oh, he was saying these things to me. No, he wasn't. If I'm not a witness to it, no, he isn't. And the video shows that if somebody was filming it, he wasn't doing anything wrong. So some false allegation by some crazy lady, okay, it helps them sometimes. And also sometimes it catches bad police officers. Here, what we have is a situation where you have a right to do it. And so for those reasons, I ask that you grant the appeal and reverse this man's conviction.
Anything else from the state?
I would only briefly say that in the Floyd case, no one was arrested. That's what the distinction is there. So people were allowed to film the encounter, and obviously other things happened from that case. But the issue is not that they were filming, that no one was arrested there. And the case law makes it clear in Listen B and other ones, if there's a probability of substantial harm or death, then individuals can actually interfere and it wouldn't be obstructing. So the case law, I just want to point out that distinction, but otherwise I have nothing else.
Okay, so this time the court's gonna grant the appeal and reverse the convictions based on its First Amendment protected conduct. And Mr. Oram, you can prepare the order.
Yes, ma'am. Thank you very much, Joe.
He needs to be released from custody, so.
He'll be released immediately?
We'll.
No.
Thank you.
Thank you.
Ready, sir? No. That is an arrestable offense.
I'm sorry.